It's JEJE Vibe.
JEJE Vibe, JEJE Vibe, JEJE Vibe, vibe.
It's JEJE Vibe.
Vibe, JEJE Vibe, vibe, vibe.
We move.
JEJE Vibe, JEJE Vibe, vibe. You know it's JEJE Vibe. What's up, ladies and gentlemen? Welcome to another beautiful episode of JEJE Vibe.
We back.
Welcome to JEJE Vibe. You know I got the queen with me. The one and only. What's up, everybody? Have you guys been paying attention to the YSL case?
A grand jury indictment that was returned that included not just Jeffrey Williams, which is of some notoriety and media attention, but about 28 defendants that operated within our community between the time period of 2012 and 2022. It is our allegation that they operated as a criminal street gang and commenced to do havoc in our community. That havoc includes crimes of violence, crimes of thefts, crimes involving drugs. I've made no secret about it, nor any apology that as the district attorney of Fulton County, my number one focus is targeting gangs.
I'll tell you the response to any allegation is Mr. Williams committed no crime whatsoever, and we will fight to my last drop of blood to clear him.
It does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, that you are going to become a target and a focus of this district attorney's office, and we are going to prosecute you to the fullest extent of the law.
Interesting.
It's crazy. There's so many things to talk about in this case. I think
This episode might look like a series after all.
it has to be serious because we can't just break it the whole thing down. But we're going to make it entertaining and also enjoyable for you guys to enjoy. So you don't want to miss this episode. So we're going to be talking about the YSL case and all of the dramas that has been happening.
Drama.
It's crazy.
They forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. We're going to take a break soon. Hang in there. This case is going close to, is becoming the longest case
Crazy.
in the country's history.
From sorting for jurors that took like about a year and a half or so.
Selection is underway in the high-profile trial of Atlanta rapper Young Thug and more than a dozen of his alleged associates. Young Thug, whose real name is Jeffrey Williams, is facing RICO charges in Fulton County. He's accused of being the ringleader of the gang Young Slime Life. 200 prospective jurors were summoned to the courthouse yesterday. Another potential 200 jurors are set to report to the courthouse today and tomorrow.
Crazy.
Like crazy.
Then to finally having a potential witness.
Oh my God. Lil Woody is.
That's another episode on its own.
He's like a case to study.
The worst witness.
Like how can you get that kind of witness in this case? And it's looking like this witness is the number one witness to nail the whole thing down, because he's been speaking, or according to the street term, he's been snitching.
Yes.
For a long time. He's been snitching in interrogation room. He's been talking about pointing and calling names. You guys can go check that out yourself.
And there are photos of him with some people.
And it's he has close ties. He has close ties.
Even though he claims that they are acquaintances or just people that are just, hey, what's up in the hood.
He has close ties. And this whole particular scene of this case is tied to the killing of Big Nut. And Big Nut, the murder was linked to Thug and some of his co-defendants. So,
Young Thug.
Yeah, Young Thug. You now have Lil Woody, who is pointing names and who has been calling names that has to do with this murder. So it's crazy. Now, this is the star witness for this case. So bringing him is supposed to like just seal this whole case and like let's move on to the next one. Like Tugger is gone. But right now, it's looking like
he plead the fifth.
He came in the first day
and pleaded the fifth.
Bro was like,
Good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Well, are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
right out of the bat.
Like straight up, bro was like, nah. The judge asked him, "Are you willing to testify?" He said, "Yeah." And then they asked him, "How old are you?" Bro, like it took a whole minute for him to give us an answer before he said he pleaded fifth. And he was held in contempt, taken to jail for the weekend, came back on the Monday.
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
A whole new set of drama started
with the lawyer,
and the judge.
Yep,
crazy, like, crazy. So the lawyer was saying that there was an ex parte communication that happened between the witness, the prosecutor, and the judge, and none of the defendants.
Lawyers or representation were present
for this ex parte meeting,
and you cannot have that meeting without both parties being present, including the judge and the prosecutor.
Crazy,
even if it's behind the bar.
Facts.
Supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Miss Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Miss Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes.
What Tugger's lawyer was able to do was he cited a case in Georgia that stated that anytime there's an ex parte communication between the witness, the defendant has to be there unless the defendant forfeits and say, oh, we don't want to, or they waiver that decision.
Yes, but they did not give them that option.
But the option wasn't given.
So now it looks like the judge is already taking a side.
It's crazy. And there was a whole drama again.
And you haven't answered my question yet.
I'm not
How
going
did
to
you
answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was
come from. I don't want to be
from.
held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what, I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Because of that, since Tugger's lawyer refused to give the name of who and where he got the information from, the judge said he was going to hold him in contempt.
Which he is not liable to, because it's highly confidential because he's a lawyer that he's representing the defendant now. So whatever information they have is confidential. They don't need to reveal the source.
Facts. So according to him, is attorney work product. So where he gets his sources from, he's not supposed to disclose that to the judge. As long as he has an information and that information happens to be true, then
at least they can actually talk about it in court, before it's been dismissed or whatnot.
So that led to
the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
She was the same person that brought out the case of Fannie Willis having an affair with Nathan Wade.
Yep.
So she's a Trump lawyer, and she came in, and she's also the head of Strike I think they call them strike force. So they're lawyers or attorneys that stand for.
So she had to represent the lawyer that was being held in contempt.
And she came in.
Criminal contempt.
So they had to now ask the judge, is it a civil or criminal contempt that you're holding the lawyer for?
It's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the In re Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeal 66, lays out the distinction.
So if you're asking for an information, if you want him to give you an information before you can let him go, it sounds like a civil
contempt. Yeah.
And if you want to punish him, then it looks like
it's
a criminal.
And he's not convicted.
So
why punish someone?
It's crazy.
Crazy. You didn't even go from the civil. You jumped right to criminal.
Crazy. So the judge right now, he stood on business.
Yeah, we watched the lawyers school the judge now on law.
Crazy.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is In re McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, In re Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. In re what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia App.
Georgia App.
372.
Okay.
Also 215. Georgia App.
I'm not asking this to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications.
And the judge stood on his 10 toes. He was like, nah, I'm holding you in contempt. This is going to be criminal contempt. You're going to go to jail 20 days. 2 days a week, which is going to be 2 weekends.
So the lawyer loses his weekends for the next 10 weeks.
Crazy. So that was a crazy drama been happening in this whole YSL case. Lil Woody is back on stand, and he is. He is.
That's another comedy show on its own.
It is like just going crazy. He's
prolonging one question. What do you mean one question? One word.
Okay, let me make myself clear, right? Because you keep asking me about things I don't told investigators in the past. I can't say from when to when, but so much was going on. My name was on everything. The police kept coming to grab me. Every time they grabbed me, I had a different story for them. I know 100% facts, and I'm telling you now, I was not truthful. I was saying whatever they wanted me to say. I was saying whatever I could come up with. I was trying my best to convince them that I didn't do nothing, that I'm an innocent person, and that people put their hands on me. When they ask me about any of these things, you sitting here keep asking me step by step by step by step. And I'm telling you now, because you asked me, was I being truthful? Okay. I know I wasn't being truthful.
So is your testimony today that you lied in every interview that you did in 2015?
Well, see, you the way you asking that, I don't recall what I was saying in the interviews, but I'm telling you now, when they was questioning me, 2015, 14, whenever they was questioning me, I was lying. I was making up stories. So when they were asking me about this right here, I was making it up. When they were asking me about this right here, I was making it up. And when they was getting me and they would let me go, I'm just telling you.
Do you recall telling every detective?
Every time they got me, I have told the police, I tell y'all whatever y'all want to hear, just let me go.
Do you recall telling every detective in every interview, you got to believe me, I'm telling y'all the truth? Okay.
That sound like me.
Do you recall telling every detective in every interview that you can go fact check what I'm telling you?
Say that again?
Sure.
I think in one of the interviews, they was locking me up and my child's birthday was coming up. And when they got me, I said, listen, man, whatever y'all want me to say, I would tell you right now. Just tell me what to say and I would say it. Tell me what y'all want to know and I would tell you. So if they would have asked me about President Trump, I would have had a story about Trump. If they would ask me about you, I would have had a story about you. Whatever to convince them that I ain't do nothing, it wasn't me. That's what my intention was. So you're asking me about interviews, and I keep telling you, you keep asking me step by 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 step. This is what I did. When they got me on this day, and I was going to jail, I tried to come up with something to tell them. That's why I can't tell you what I said. I was making it up.
What benefit would it be for you to lie to the police if you were trying not to be in trouble?
I was hoping to convince them so they could let me go.
So why would you lie to convince them?
What you mean? Why would I lie to convince them?
Right. Why would you lie to convince them if you wanted to not go to jail?
Why would I lie to convince them to not go to jail?
Right.
But they don't know that I'm lying.
Well, they didn't let you go immediately, did they?
Sometimes they let me go.
Right.
So when the time they let me go, I thought I was smarter than them.
Did the detectives say that they had to fact check what you said before they let you go?
Can you say it again?
Sure. Did the detectives tell you that they had to fact check what you were telling them?
And you know, in some situations.
Right. And so what benefit would it be to lie if they told you that they had to fact check it?
Oh, it wasn't no benefit because what they did was they picked and choose what they wanted to take from me, and they still left me in jail, so they came back and beat me in the butt.
Okay. 164 Echo Hotel and 164 Echo.
Get back.
All right, well. Excuse me. Sure. I'm sorry. Can you take a break?
Nah, I said excuse me.
Oh, okay.
Looking at
So Lil Woody is a crazy snitching case study. Like
crazy.
You gotta say, man, this is a new case to study, because
We're gonna have another episode for Lil Woody.
It's crazy.
So,
there's been a response from some of the Supreme Judge in the case that states that the lawyer is right.
The judge who has been overseeing the long-running racketeering and gang prosecution against Young Thug and others in Atlanta, he has been removed from the case after two defendants filed motions seeking his recusal. The defendants cited a meeting with judge held with the prosecutors and a state witness. The defense was not invited to that. Fulton County Superior Court Chief Judge Uriel Glanville had put the case on hold 2 weeks ago to give another judge a chance to review the recusal motions. Judge Rachel Krause on Monday granted those motions and ordered the clerk of court to assign a different judge to the case.
So this ruling is going to cause even more delays in a trial that's already dragged on for over a year. Jury selection began back in January of 2023. It took nearly 10 months for them to seat a jury, and then opening statements were in November of last year. So this case, just the trial, has been going on for 8 months and over. Now, the prosecution has been presenting its case. They're still in their case in chief. They've called dozens of witnesses at this point, but what's going to happen now?
YSL RICO trial involving Atlanta rapper Young Thug, and less than 24 hours after replacing the original judge, the newly appointed judge has recused herself. Judge Shakura Ingram was randomly selected to lead the trial after the former judge Earl Glanville was removed yesterday. Ingram says she is removing herself from the case due to a prior professional relationship with a deputy involved in the case. Deputy Christian Eppinger is accused of sneaking contraband to a YSL defendant. Eppinger also serves as Judge Ingram's courtroom deputy. He did that for 6 months. Right now, it's unclear who will take over that trial.
It's looking like it might be a mistrial.
It's looking like this case is looking crazy. But don't worry, guys. We'll be back with more updates. Hope you guys enjoyed this video. Don't forget to like, subscribe to the channel, and you're welcome to the JEJE Vibe family. Catch you in the next one.
Bye now. It's JEJE Vibe. It's JEJE Vibe. We move.